the evidence that I presented, and even in the last document that I gave you, the state law, Mr.
I just said we didn't need the narration. So you just give us the evidence.
I'm giving you the evidence that requires narration.
No, Smith, so you can let you
The evidence that I presented to you clearly indicates that Mr. Flagg has lived at 111 Laurel Lake Drive since June 24th of 2004 until present. He recently sold that residence, or intends to sell that residence, and you have proof or documentation somewhere that you said that it was on the 5th of March of this month. I don't care how you cut that. And I'm still saying it take 2 years. But you said you were dealing on the 30-day resident. Even if you were dealing on the 30-day resident, there's no way that George can move out on the 5th of March and move into the city of Pittsburgh and been there 30 days. The Supreme Court ruled on September 7th, 2012, in very strong language, that the resident requirement to qualify for an office set forth by that city or a jurisdiction, a municipality, stands. And that whatever that law was, it remains because they struck down the circuit court verdict of requirements of how long a resident requirement was to require 2 years. So if the Supreme Court, which is the Supreme Court of this state, make that finding, why do you not consider that's the law? I guess that maybe you didn't have this law. It's the reason you made the decisions you made. Ms. Fondren lived at Fondren Drive off of Tucker Road. She bought a house, or leased a house, or rented a residence on Cherry Street. She's been there for 30 days, or over 30 days. She does not meet the requirements the city has set for 2 years. That's the law you have to go to. That's where she lived. That's where she laid her head. That's what this law says. And if it's anything other than that, you're in violation of the law. I'd just like to add, in summary, that based on these facts that I presented to you concerning Ms. Fondren and Mr. Flagg, this committee has no choice but to call both of these individuals who are candidates for the mayor of Vicksburg to testify under oath to their true residency. The burden of proof is on them, not on you or anybody else. They have to prove that they live where they say they live. And if they can accentuate that evidence, and none of what I've heard since I've been here, and I've been here since the meeting started, nobody has presented proof. And you can't use whether they register their car as a resident, or whether they pay utility bills at a certain residence, is where they actually lay their heads and sleep, where their clothes are. And if they don't meet that requirement, under this law, you have to disqualify them.
Mr. Chairman, I'd like to respond on behalf of the to the gentleman. May I proceed, sir? Yes. The gentleman may be entitled to the facts, but he's not entitled to what the law is.
I didn't write the law. The court wrote the law.
Let him talk. Yes. Mr. Chairman, ladies and gentlemen, the gentleman did acknowledge one thing and did respond in favor. He acknowledged that she had been on Cherry Street for at least 30 days. We do appreciate the gentleman for that, but the law of this state is clear that you only have to be at your residence for 30 days for voting and to qualify for office. That's the law. Now, let me just read, and you have, because you mentioned the George Flagg's opinion. This is what the Attorney General said. The foundation of domicile is intent. This intention may be established by physical presence, declaration of intent, and all relevant facts and circumstances. And in this connection, it has been held that the declaration of the party himself are most important. The declaration of Ms. Fundra is most important where her residence is. I haven't heard anything to the contrary tonight, other than a lot of speculation and surmise. I see no reason for you not to revisit before we leave here. Reconsider taking this, and let's move on, because she's entitled to be on the ballot, and you just delaying what eventually going to occur. So why are you delaying her right to be on the ballot and to campaign as other candidates? We are almost less than 45 days prior to the election. It's time for this committee to do the right thing.
Ms. Ferguson, we're not going to be going back.
That's right.
Well, you let him come forward. Unless you did. He had finished his hour and come forward.
You did a challenge without giving them privilege to the information. So they heard some of the information, they had a right to respond.
That's right.
And that's the end of that.
I'd like to request a vote on whether I can make a comment concerning the law as passed by the Mississippi Supreme Court and what it says. Not what I said, what it says.
The chair asked the committee, are we going to accept Mr. Ferguson's challenge and go forward with it, or are we going to dismiss it on grounds of frivolous because he's working on the 30 days?
All of that is addressed in this too. It's not my law, this is the law from the Supreme Court. And there's no other law higher than that. And you got to remember that the Attorney General has an opinion. We all got one. It's an opinion. That's all it is.
say that, we stand as we vote.
Three days, I think it took 3 days.
I dismiss the challenge.
Second.
Yes, she second. She said it all.
I second.
It's been moved that Mr. Ferguson challenge be dismissed on the grounds of frivolous. Because of the 30-day requirement that we're working on. All in favor? All opposed? The ayes have it.
Mr. Chairman, I rise for a point of personal privilege to ask the committee at this point, based upon newly discovered evidence brought by Mr. Ferguson, to reconsider the tabling of the.
It's nothing new
Well,
that we put in that we didn't already know.
He's the only witness who testified that she lived on Cherry Street and been there 30 days.
That wasn't in the testimony. I'm repeating what I heard.
How do you think we knew the number of properties that she owned, homes that she owned, in the vehicles, the number of vehicles that she owned, if we did not already? So we already
applaud
knew
you
that.
highly. We applaud you highly for
The
conducting
committee
your thorough
asked
investigation.
for to take what we discussed about her new registration and all that under advisement for the 3 days, and that's what they want to do. Okay.
Thank you.
That we all. This committee adjourned.
Are we?
Rolling.
5, 4, 3, 2.